One man sued a woman and her son some time ago to claim the paternity of a 57 years old man. He claimed that he had sex with the woman some years before then, and as a result of the sex that he had with the mother that time, the mother gave birth to a baby boy then that has now become a man of 57 years old. He claimed that during that time the woman was married, but her husband was ill, and as a result of the illness, both of them can't have sexual intercourse, and as a result of this, woman was sexually hungry and the woman had to come to him, and as a result of this, he had sex with the woman and the woman gave birth to a bouncing baby boy that time. The first, the second, the third, the fourth, the 50 years after the sex, the man was still in the city, going around, going from one country to another, catching fun and catching cruise here and there. Now, when this man now came to the court, he was praying to the court to restrain that old 57 years old man from bearing the name of the father that he was bearing before, and that the man should take his own name as his own surname. That is his prayer to the court. But before he can prove that he is actually the father of this child, of this 57 years old man child, he had to provide some evidence to prove to the court, because according to section 131 and 132 of the Evidence Act of 2011, he who asserts must prove. And this is what the court is actually asking from him, to prove his case. And the only thing that he could use to prove his case in this kind of circumstance is DNA test. At the trial court, what did he do? He prayed to the court to force the man to follow him to the hospital to do a DNA test. The court said no. The court said it can't force a 57 years old man to go and do DNA test, because if it does so, it will be a contravention to the provision of the Constitution that is entrenched under Section 37 of the Constitution that provides the right to privacy. The trial court had to dismiss the case. Agreed by the man, he appealed to the Court of Appeal, praying that the Court of Appeal should help him in this matter. What did he want? He wants his child, his 57 years old child, his 57 years old child back to be bearing his name. And at the same time, he wants the court to compel that 57 years old man to follow him to the hospital to go and do DNA test, so that he will ascertain that the child of 57 years old is actually his own. What did the court say? The court said that forcing a man, a grown man of 57 years old, to do DNA test will be a contravention to the right of privacy as entrenched under Section 37 of the 1999 Constitution. And at the same time, the court will never aid injustice. For this reason, the court had to dismiss their application. By implication, this means that nobody can force you as a grown man, as a grown adult, to go and do DNA. Nobody can force you. If you willingly follow them to do the DNA test, or you willingly go to the hospital to do the DNA test by your own self, yes, that is fine. But even the court cannot force a person to do DNA test, because it will be a contravention to the right of privacy that such a person has. And this is another episode of my law class at Abdullahi Academy. My name is Abdullahi Abdulrauf. Do not forget to subscribe to our channel on YouTube, and also like and follow our Facebook page with our username, which is Abdullahi Legal Academy. Till another time that you and I shall be meeting, I wish you a wonderful legal day ahead.